The Firearms Policy Coalition says it will aggressively challenge laws in the U.S. and looks forward to continuing it all the way to the Supreme Court if necessary. On its website, it celebrated the ruling, saying, in his order, Judge Benitez held what millions of Americans already know to be true. Bans on so-called assault weapons are unconstitutional and cannot stand, said President Brandon Combs. The historic victory for individual liberty is just the beginning.
There's now a buzz in the gun community that Judge Benitez's ruling on the California assault weapons ban should be applied to other states. Welcome to another installment of the Connecticut Gun Bench. Today's video is brought to you by P.A.N. Firearms, LLC. P.A.N. Firearms, the NRA certification and multifaceted gun training. You can reach us at 203-300-6343 or use our website at www.panfirearmsllc.com. As always, there'll be a link in the description box below. And if you like my channel, like my content, and what I do here, you can support me with the link. Everything is appreciated. Let's talk about this. Now, if you remember yesterday, I did a quick video on California's assault weapons ban. I believe it's Miller versus Bonta. And Judge Benitez, my hero, ruled once again for the second time on the same case that California's assault weapons ban was unconstitutional. In his first ruling, he said it was a failed experiment. Now, that case is once again going to go back to the Ninth Circuit for the second time. And we're going to have to wait and see the outcome of that. But the Ninth Circuit is very liberal. So there's no doubt in my mind that they're going to reinstate the ban, saying that it is constitutional. But there is now a little bit of a buzz going on among the gun community. And some are saying that his ruling should apply to other states. I want to come into here. And ruling destroying California's gun ban should now apply to Washington State. Thursday ruling by U.S. District Judge Roger T. Benitez, which struck down California's ban on so-called assault weapons, should have a direct impact on a similar ban in Washington because both states are in the U.S. Ninth Circuit, the Second Amendment Foundation says. Now, in my opinion, his ruling should apply for the entire country. He is a federal judge in a district court. But unfortunately, that's not how things work. But that's why things go so damn slow and take forever to get any kind of ruling because Miller, if I'm not mistaken, has been going on since 2021. But, quote, if a gun ban in California is unconstitutional, SAF founder and executive vice president Alan M. Gottlieb observed, it is just as unconstitutional in Washington state. Of course it is. But we are eager to see this case through to what may become a Supreme Court confrontation because we are confident that we will prevail. People who support gun bans like California Governor Gavin Newsom and Washington Attorney General Bob Ferguson are wrong on this important constitutional issue. The case is known as Miller versus Bonta, filed by SAF, the San Diego County Gun Owners Political Action Committee, California Gun Rights Foundation, Firearms Policy Coalition, and 4 private citizens, including James Miller, for whom the case is named. They are represented by attorneys George M. Lee at Cellier Epstein LLP and John W. Dillon at Dillon Law Group, APC. Notice the NRA is not mentioned in this, and that's very disappointing. Okay, and if you remember when I did a video yesterday, I talked about this a little bit, and this Judge Benitez put out some based facts when it comes to this ideology of assault weapons bans. But in his 79-page ruling, Judge Benitez wrote, while criminals already have these modern semi-automatics, the state prohibits its citizens from buying and possessing the same guns for self-defense. At the same time, these firearms are commonly possessed by law-abiding gun owners elsewhere across the country. Guns for self-defense are needed a lot because crime happens a lot. A recent large-scale survey estimates the guns are needed defensively approximately 1,670,000 times a year. Another report originally commissioned and long cited by the Centers for Disease Control and Prevention estimated that there are between 500,000 and 3 million defensive gun use in the United States each year. And I want to point out that it was last year, I believe, the CDC, under pressure from anti-gun groups, changed that self-defense numbers because, quote, it would hurt their cause, talking about the anti-gun groups. Judge Benitez's ruling is a stinging rebuff to the gun prohibition movement, said SAF Executive Director and Adam Kraut. His detailed discussion of the history of firearms regulation, along with his dismantling of the state's arguments and assertions of its experts, sends a signal that the days when gun banners could simply attack the Second Amendment without challenge are finished. Quote, "We will take this challenge to the Supreme Court if necessary as part of our commitment to restore firearms freedom, one lawsuit at a time." And come out that little bit there, but as I said prior, technically this should apply to the whole country. It's a federal judge, but because of the system, that's not going to work out that way. Now, it's interesting that they're saying that this ruling is going to have an effect on every Ninth Circuit district lawsuit. And it's rightfully so. It all goes to the Ninth Circuit. But Judge Benitez, and I'll point out another thing here that he said during one of his rulings, they had an expert who testified pro assault weapons ban. And the person's name is Ryan Buss. Ryan Buss, if I'm not mistaken, he's part of the Giffords Foundation, the anti-gun group, Gabby Giffords' little group there. And Judge Benitez kind of eviscerated this guy's expert testimony by stating this. The state offers declarations from a number of other expert witnesses to address subjects other than historical analogs. In general, these are subjects that this court has already addressed in its earlier opinion and is beyond the Court of Appeals remand order. Nevertheless, some of these opinions are mentioned here. Ryan Buss is a Giffords senior advisor and former firearms industry executive for a manufacturer and seller that specializes in pistols and revolvers, but not AR-15 platform rifles. The few rifles sold by his former firm are traditional style bolt-action models. Buss opines that a firearm does not need any of the devices, accessories, or configurations listed in the assault weapons ban to operate as a gun as intended or to use a gun effectively for self-defense. It is not at all clear what expertise Buss has to support this opinion. He does not describe any professional experience using AR-15 platform rifles for sport or self-defense. In any event, this type of opinion is not relevant to the question of whether the state may ban a firearm that is commonly used by law-abiding citizens for lawful purposes and does not fit the prerequisites for Federal Rule of Evidence 702. So once again, this judge, pretty much using based facts, eviscerated this opinion by a person who has no experience specifically on the AR-15 platform. But because he happened to be in the gun industry as a manufacturer, they propped him up as some kind of expert. But that didn't work out for him with this judge. So technically, yes, every case in the Ninth Circuit that involves assault weapons ban should fall under Judge Benitez's ruling. So if that's going to happen, I highly doubt it, because then Washington State, or the people who live there who want to challenge the assault weapons ban in Washington State, are going to have to bring suit to the courts based on this judge's opinion here. I find it interesting that the process that we go through, and I've spoken on this several times, this process is inefficient, overburdened, onerous, and does not embrace the Constitution for a quick and speedy trial. Now, some could say that's a criminal trial, but I say that's for anything where you go before the courts to argue a position. It's very interesting that they're saying this. We will see how it goes. But like I said, the Ninth Circuit is a very liberal court. So no doubt they're going to reinstate California's assault weapons ban, and it should go to the Supreme Court after. And this is what we need. We need one of these cases to go before the court and have the court rule on it. But the anti-gun community, the anti-constitutionalists, the left, whatever you want to call them, know for a fact that this court with this makeup is going to overturn any assault weapons ban. So they're going to drag this out as much as they possibly can in the hopes that the court's power will shift in their favor. And that's unfortunate, because it's not supposed to be about feelings. It's supposed to be about the law and the Constitution, which is the supreme law of the country. But I found it to be a very interesting take from the SAF that this should apply to every Ninth Circuit everything in the Ninth Circuit's jurisdiction when it comes to this specific issue. But let me know what you think. As always, you can leave your comments in the comment section below. And as always, any statements of violence or statements that lead to violence will be removed. Please like, share, comment, subscribe. Don't forget to hit that notification bell so you're notified the next time a video goes live. I'll see you on the next one. Peace.